Now we'll tell you about a constitutional court ruling that's been held as a victory for the media. The court has declared the regulation of interception of communication and provision of communication-related information Act or Rica unconstitutional insofar as it did not provide adequate safeguards to render it lawful. The amaBhungane Center for Investigative Journalism and its managing partner, Sam Soul, had filed an application at the Apex Court for confirmation of the 5 orders made by the High Court in September last year, declaring Rica unconstitutional. Rica is the law which permits the interception of communications of any people by authorized state officials subject to prescribed conditions. To talk about this, we're joined now by Cherese Thakur, who is Advocacy Coordinator for amaBhungane. A very good evening to you, and thank you so much for speaking to us. Perhaps let's just first start with a bit of background on why in 2017 you as amaBhungane and Sam Soul went to the courts to give effective to this ruling.
Well, the matter arose from the personal experiences of our managing partner, Sam Soul. He noticed that in a different court judgment, a completely unrelated court application, his personal communications with an advocate were attached to those papers. And this was obviously very unusual and quite concerning to him. So this is the genesis of our litigation. And that prompted amaBhungane to go to the High Court to have these concerning provisions of Rica declared unconstitutional.
So he obviously also found out by chance. So how did that happen, and why is this a victory?
So as I mentioned, he was informed that it came about through a different court matter, but this is a victory because one of the aspects of Rica that were declared unconstitutional is the failure to provide for post-surveillance notification. So this is where once the surveillance has ended, the state security agency is required to inform you that you were the subject of notification. So if that was the case, Sam would have been told that he was his communications were being monitored. So this is a very important provision because if you are now given that notification, you can go to court and challenge the lawfulness of that interception of your communication.
And we'll get to post-surveillance notification, but the ruling also calls for the provision of notifying a subject as soon as notification can be given without jeopardizing the purpose of surveillance. So it is very clear that there has to be even warning prior to surveillance being carried out.
No, that's not the case. So that's what I'm referring to. It's called post-surveillance notification.
Okay.
So the purpose of surveillance is the government can monitor people's communications for purposes, for instance, of preventing crime. So it wouldn't really serve the purposes of preventing crime if they could tell you in advance
that
it would be monitoring you.
As you say, post. But what I also find interesting, it talks about the independence of an judge appointed. I mean, we're told that the judiciary is inherently immune to outside influence. So what would your interpretation of this be in terms of, independence? But the ruling also states about data obtained through interception that it must be used lawfully. Again, there's an assumption that if somebody falls victim to this, that this would be observed.
Right. So the independence of the designated judge is very, very important. The government tried to raise the argument that judges must be and are independent, but it's established jurisprudence that there are certain influences that can impact on the partiality of a judge's decision. And I think it's in particular the clandestine nature of these decisions that are made, the directions that are issued by the judges to authorize this interception of communications that make it very important that the designated judge is very, very independent and that there are necessary safeguards to ensure that independence. So that is a very momentous and important confirmation by the Constitutional Court that independence needs to be in place.
So Just to your mind, what circumstances would you say are justifiable where journalists must be surveilled given the sensitivity of sources in an investigation? And to your mind then, what would be foremost in those RICA safeguards that you believe should be the first port of call?
We would argue and of the view that the surveillance should be conducted against journalists in only the most limited of circumstances. Really, if there is, if the journalist themselves is involved in a crime and it is a legitimate use of that surveillance power to investigate and prevent that crime or investigate that crime, it's really not to be used to monitor and spy on journalists and the communication that they have with their confidential sources. And what was very encouraging in the Constitutional Court's judgment is that it affirmed the importance of that confidentiality. So the Constitutional Court read in a protection for that communication between journalists and their sources by saying that if you want to intercept that type of communication, you have to jump through extra hoops. You have to really show that there's a real need to do this for the purposes of RICA, the legitimate purposes of RICA. And I just want to add that that protection also extends to the interception of communication between attorneys and their clients. So they're given a similar extra safeguards in this Constitutional Court judgment, which is great.
And just very briefly, do you believe that this will have a global precedence? Because I am aware, and I think Dario Miller also tweeted, that there is a high-level panel of experts, legal experts on media freedom that's sitting at the moment to look at some of these issues.
Definitely. And I just want to mention that in 2017, when the High Court handed down its judgment, which found on quite a few similar bases that RICA was unconstitutional, but also importantly that bulk surveillance was unlawful, Edward Snowden actually took note and he tweeted, "Wow," in response. So the world is watching, and it's important that South Africa brings its surveillance legislation up to international standards, but also importantly up to the constitutional standard.
Thank you so much.
And that's what this judgment affirmed.
Thank you so much for your time. Cherese Thakur is the Advocacy Coordinator for amaBhungane.